Thank you, Catherine, and it's so great to be here today. My name is Matt Ader, and I'm the Vice President of Business Development at Vispero. And I'm going to talk to you a little bit about TPGI, and then I'm going to introduce the rest of our speakers today, panelists. So TPGI is a division of Vispero. TPGI is an accessibility company who helps on everything digital accessibility. And so that's anything from websites and documents, mobile applications, kiosks, payment devices, things of that nature, and has a long history of providing these types of services and experts around the world to help companies deal with their accessibility challenges. I have myself, I've been in the field for 30 years in both assistive technology and accessibility. I am blind, so we'll have lots of folks helping out watching the chat and QA section so that we can focus on this great opportunity to chat today. I want to introduce our panelists today. So Alejandro Melito. Alejandro, would you like to introduce yourself?
Thank you, Matt. Good afternoon, everyone. So yeah, my name is Alejandro Moledo, and I'm the Deputy Director and Head of Policy at the European Disability Forum. And I was one of the lucky ones that got the privilege of seeing the European Accessibility Act when it was requested and demanded by the European disability movement just as an idea, and how this developed into a proposal for a legislation, then how the legislators at European level changed it. And now when member states are introducing national laws, how these are being applied at national level, and obviously all the remaining tasks that we need to do to ensure implementation of this very important legislation on accessibility that for the disability movement has been definitely a turning point as for our legal framework concerning accessibility to the EU internal market. So very happy to be here and answer as many difficult questions as possible.
Excellent. Thank you very much. And I'd also like to introduce David Sloan.
Thanks, Matt. Hi, everybody. I'm David Sloan. I'm the Chief Accessibility Officer of Vispero, TPGI's parent company. I'm also the manager of TPGI's user experience services. So that includes anything from usability testing with people with disabilities, digital products, through to JAWS scripting and kiosk consultancy support. I've been with TPGI since 2013, and before that was an accessibility researcher, teacher, and consultant at Dundee University in Scotland. So I am European, even though I now live in the US, and I'm very interested to see the implementation of the European Accessibility Act and its impact on people with disabilities across the continent and beyond.
Thank you, David. So I want to jump into a little bit about first Alejandro, this European Accessibility Act, this affects all European states, correct?
Yeah, all member states that are, all countries or European countries that are members of the European Union, and also it will have an impact as well on the European trade areas, yes.
And do the member states have a opportunity to choose what they consider to be the requirements, or is this kind of like top level down?
No, basically what the European legislation does is setting, let's say, a minimum harmonization across the EU, because as I mentioned, the European Accessibility Act is not an anti-discrimination legislation. It's not related as such about persons with disabilities and their rights. It obviously has an impact and a positive impact on our rights as persons with disabilities, but this legislation is basically about the European single market. So one of the core values and elements of the European Union is this free movement of products, services, capitals, and people. And with the European Accessibility Act, the EU has set a minimum set of accessibility requirements for certain products and services to ensure that there is not market fragmentation. So to ensure that basically a European country will not introduce certain accessibility requirements that would be contradicting another EU member state accessibility requirements. So basically what we achieved is, let's say, a coherent approach to the level of accessibility that certain products and services should comply with. So a member state, once complying with these objectives laid down in the European Accessibility Act, they can obviously, and we have been advocating for it, they can obviously go beyond, meaning not to introduce diverging accessibility requirements, but for example, to introduce or to make use of those accessibility requirements for other products and services that are not covered by the European law. For example, the European Accessibility Act sets accessibility requirements for the European emergency number, which in our case is 112. So our recommendation to member states has been, listen, now that you are introducing legislation to ensure that the European emergency number 112 will be made accessible, or there will be an accessible way to communicate with the 112, why not to include as well the national emergency numbers with using the same accessibility requirements as for the ones for the European numbers. So this is the kind of approach that the European disability movement is taking at national level when transposing this directive. I must say that, unfortunately, member states, when transposing, as we say, so when introducing new legislation, new national laws, or amending existing national laws, unfortunately, they have not been as ambitious as we would have liked to.
Thank you. David, when we think about the types of technology that are covered in this, and we think about some of the standards, so what would some of the technology that someone who's developing or selling or building, what's some of the technology that would be covered under this law?
So the law really, it looks at two related areas. There's products and there's services, and the products tend to be the machines, the hardware with software running on it that people use in order to access and interact with services. So products might include kiosks and self-service terminals, or e-readers, or computer hardware, or products that enable access to audio-visual media services. So they're covered. And then the services that are offered through those products and other products are also covered. So the electronic communications, the way that you access audio-visual media, a media player for streaming services, for example, a consumer banking mobile app, an ebook, and the software running on the e-reader, and e-commerce websites, they would all be covered as well. So we're really looking at hardware and the software, the user interface that's running on a hardware product. They are all covered.
So I want to jump into an example, because I think you led into something. And Alejandro, if I am visiting, or if I'm a customer of a bank, for example, and I love examples because I think they help drive home something. So I may use, and feel free to jump in here and tell me your thoughts on this, but I may use a website to create an account. Would that be covered?
Yes.
Did I lose you?
No. I'm here.
Yeah.
Yes.
Would
yes.
that
The
would that
answer
be
is yes.
covered?
Yes.
Yeah.
It's
And
a
then
consumer banking service through website and mobile applications.
right.
They are covered. Yes.
So if I want to check my bank account and make a transfer to my daughter using the mobile app, that would be covered.
Yes.
Okay.
Yes.
And then if I went to the bank and wanted to get money out of an ATM, would that be covered?
That is the when it gets funny, because the ATM is covered. So the self-service terminals, including ATMs and also payment terminals, are covered. But the built environment for the provision of the service, this depends on the national law. So this depends whether the EU member state has decided to cover the built environment of the service or not. So we may have the paradox of an accessible ATM in a bank office that is not accessible. That could
Right.
happen.
So someone in a wheelchair may not be able to enter that building.
Yeah.
Right. Okay. But the digital requirement of the physical unit
Yeah.
is
Yes.
required, but it may not require access to it, which seems a little weird, but okay.
It
got
is.
that.
It is. We made this example quite often, but member states were not willing to accept that Brussels tell them how to make the built environment accessible, unfortunately.
Sure. Yeah.
Mm.
And so, David, if I did a similar example for you, and let's use a grocery store as an example, I may order my food ahead of time from a grocery store's website. I mean, that's very common in the United States. I don't know how common it is in Europe. But then I tell in the app that I want to pick it up. So I go there, they may put the stuff in, say, a locker. That locker has a digital interface, a touch screen or something that I need to go use to get the food out of the locker. Would that be an example of something that I had to buy stuff on the website or in an app? Then I went to the store to collect my goods. Would that be something you'd see to be covered?
It's a good question, and I suspect it would. I mean, I'm gonna sort of step back and say I'm not a lawyer, and
we brought no lawyers to this meeting.
but my interpretation of the products covered would be that if you in trying to receive the service provided, you had to interact with a website or an app, and you also had to interact with some kind of physical device like a smart locker that is effectively a self-service terminal. It would seem to me that it's all covered as part of the same service and the product that you interact with in order to receive the service. So I would say yes, and I'd be interested in hearing a counter argument to say that it wouldn't be covered.
Any comments to that, Alejandro?
Well, the intention of this legislation is to create as well as spillover effect. So by addressing the manufacturers of self-service terminals or payment terminals, the idea would also be that given that they must comply with the accessibility requirements, and actually they will be requested by their clients, transport services, banking services, and so forth, to comply with this law, the idea would be that they would by default consider accessibility in the production of their products. So one could argue like, okay, a small shop in my street may not have a self-service terminal that is accessible, and maybe they are not covered by the law because they are a micro enterprise. But the manufacturer creating these self-service terminals would use the accessibility requirement, or that's the intention of the law, that they would also be applicable when they sell these products to all sorts of services. So
that's a great question. So like ultimately, and either one of you guys can jump in on this. I welcome this answer. Who's ultimately responsible? Because I could see where if I'm a company and I decide to buy something from a third-party vendor to put into my store or pay somebody to build my website, am I responsible to, because I'm providing the service through that website, am I responsible as the company who bought and paid for the website to be built, or is the company who built it responsible for this? And a website's an example, a self-service
Yeah.
terminal is an example, mobile app, it doesn't matter.
Yeah. Well, let's repeat the warning that we are no lawyers, and
Sure.
but in the example you made, I believe that you would be responsible because you are providing the service. So if you're a bank or you're an e-commerce, which is accessed through a website or a mobile application, you are covered by the legislation. So if you don't request to your vendor that they deliver an accessible website, you are liable for not complying with the legislation. Is the same approach as for other domains like safety, environmental legislation, and so forth. So it's the same kind of rationale. So you would be liable in this particular example. This is my interpretation as a no lawyer.
Yeah. Well, we've made it clear that none of the three of us are lawyers here. And lawyers will have fun with all of this stuff. So yes. In terms of, everybody wants to look at standards. So, and David, we have WCAG out there, and obviously it's a good foundation. What should, if I'm somebody who's building a website and a mobile app or an application of some sort, is that enough that I just go look at WCAG and I'm done? Is there something else that somebody should be doing to making sure that they're following these rules?
It's a great question, and it's also one that some people have been asking in the chat in terms of an official standard and whether there's variation from member state to member state. And the text of the Act is non-specific in terms of a technical standard that you have to conform to. Instead, there are a number of functional requirements plus additional accessibility requirements for specific products and services. There is regular mention of 4 principles of accessibility: perceivable, operable, understandable, and robust. And anyone who's familiar with WCAG, the Web Content Accessibility Guidelines, will recognize those 4 principles as the guiding structure that WCAG is built around. So effectively, because the EAA reference or talks about existing harmonized standards for EAA, if you can demonstrate that you meet an existing harmonized standard, then that is a way to demonstrate conformance with the EAA. And EN 301549 is a standard that is considered a harmonized standard across the European Union. So if you can show that your product or service meets the requirements of EN 301549, whether it's a web application, a mobile application, a digital document, or a piece of hardware, then you should feel comfortable that you've met the requirements of the EAA. EN 301549 directly references WCAG version 2.1. So any website that meets WCAG 2.1 level AA will also be in conformance with EN 301549 and should therefore also meet the requirements of EAA. Now, EN 301549 is currently undergoing revision, and it's unfortunate that the revision process, as I understand it, will take longer than the June 28th deadline of 2025. So we're not going to see an updated EN 301549 until after the deadline. So for now, focusing on the current version of 301549, and by extension, WCAG 2.1 level A and level AA, that will at least get you on a good foundation for conformance. And to my understanding, that's a standard requirement across the European Union. So as Alejandro pointed out, this is all about harmonizing requirements to support the market. So having expecting to meet a standard, single standard for every country that you're doing business in is a reliable way to go.
Can I comment on this?
Yes.
Yeah. So indeed, as David was mentioning, it is a good idea to look at the current version of the EN 301549, which indeed, as for web, software, and non-web documents, is very much based on WCAG 2.1. You can already look at WCAG 2.2, obviously, level AA, level A and AA, and actually in the revision of the current EN, which EDF we are part of such revision. This will be one of the updates, but it will not be the only one. So it is already good to look at the current version. But what I wanted to say is that because sometimes we often get these questions like how are we going to comply with the Accessibility Act if there is no harmonized standard, if the standards organization are most likely being late. We will try not to be late, but standardization development and finding consensus among all the stakeholders and right holders is difficult, and conflicting interests and so forth delay the process, but we will try our best. But what I wanted to say is that, okay, you can already look at these existing standards to get ready for the Accessibility Act, but what is mandatory are the requirements in the Act. These are the ones that are obligatory for the economic operators, whereas the standards are voluntary, are a means to demonstrate compliance with the legislation. So in a way, yeah, they are voluntary, but they are kind of de facto as well part of the legislation. But at the moment, the current version of the EN is harmonized, not because of the European Accessibility Act, is harmonized to the Web Accessibility Directive, which is the legislation very much narrower on its scope, because it affects the websites and mobile applications of the public sector. Therefore, indeed, is I would say, the state-of-the-art standard on e-accessibility, on digital accessibility, that goes beyond beyond web, because it covers other kinds of technologies as well. And what is important is that everyone that is interested, you can participate in the revision of this EN. There is a GitLab for those who are really into standardization. This is a GitLab forum in which you can address or propose changes to the EN. There is also an available email addresses that you can send your comments as well. But the idea is that, okay, the future, hopefully harmonized standard, because the European Commission is the one that will decide if the standard is harmonized or not. The future accessibility standard, the EN 301549, will also have other technical requirements, or at least this is our intention, because there are some requirements, mandatory requirements in the legislation, as for example, identification. that are very important for certain services, such as e-commerce, that the current version of the EN may have not addressed sufficiently. So new technical accessibility requirements will need, from our point of view, will need to be introduced in the EN to fulfill or to detail down in a technical manner that can be useful to industry and to users and to market surveillance authorities to cover all the mandatory requirements of the Accessibility Act. So indeed, start looking at accessibility, because as we know, accessibility cannot be fixed overnight. So you can already look at the current version of the EN 301-549, which is freely available in its English version. Look at the WCAG Act 2.2, but also look at the accessibility, what is mandatory, the accessibility requirements of the act, of the legislation, the ones that you can find in the annex, because those, even if functional, will give you guidance on the outcome that you as a company or as a public administration need to fulfill in order to ensure equal access for persons with disabilities.
So
I was just
Go
going
ahead,
to jump in and just
Yeah.
underline the importance of becoming familiar with the requirements in the annex of the legislation. And I know that diving into legalese is not always something that people are keen to do, but the annex the annexes, there are multiple annexes, lay out in pretty straightforward ways what you have to do in terms of functional requirements, and then interpreting how best to do that for the product or service you're in charge of is something that you can then look to standards for guidance.
In Annex 1, you have the mandatory requirements, but in Annex 2, you have examples, which are not mandatory, but those can bring inspiration as well on how you can comply with the accessibility requirements in Annex 1. So yeah, those two are worth taking a look at.
Exactly. And for anyone familiar with WCAG and the techniques that are provided for each success criterion, these are similar in that they give examples of a way to meet a mandatory requirement.
Excellent. So one of the things that people are going to ask is, how do I, if I am building a product, making a product, what do I need to do, not from a testing perspective, but to prove conformance? Like, is there, in the United States, if you're selling to the government, you use a voluntary product accessibility template. You may use a accessibility conformance report. What is this the format or thing that companies should be planning for when looking at their products and services?
Well, the obligations as for products manufacturers, manufacturers or distributors or importers, because let's remember this is a market access directive. So microenterprises importing or distributing products in the EU internal market, even if you're a microenterprise, you are covered. The obligations for product manufacturers product manufacturers and service providers are different, but you can check the procedure which is in Annex 4 of the Annex 4 and Annex 5, if I'm not mistaken, in the Accessibility Act, and that gives you the list of the tasks that you need to fulfill, or the documentation that you need to keep and to prepare when you want to put a product in the market. This is a market access legislation. Therefore, as for other in other domains, such as safety or environmental legislation, you need to follow a procedure in order to add the CE mark that we see in products that are sold in Europe, meaning that you comply with a set of harmonized legislation. So in terms of the specific conformity assessment that you were asking, in Europe, we don't have the VPAT, which I think you were referring to, that you have in the US. In the EN 301549, if you look at Annex C, sorry, we are referring to so many annexes today, but
okay.
the kind of the juicy parts are in the annex sometimes, no? So in the EN, in Annex C, you have the conformity assessment, which is different from the VPAT approach. But these are the kind of the basically some sort of like a repetition of the accessibility requirements of the EN in a way that you can specify, okay, my product is a self-service terminal. Yes. Does it have, alternative to written information? Yes. So you can follow, firstly, and most importantly, Annex 4 of the directive, and then you will have supporting documents in the standards that are being developed. Not only on the EN, because we are talking about the EN 301549, which is the ICT standard, but there will be 5 other harmonized standards if everything goes well. So not only on ICT, because let's remember that the Accessibility Act also covers support services, covers non-ICT information, support services, I mean, to clients, non-ICT information, the communication with the emergency call centers, the design for all, so the approach of services to comply with the Accessibility Act, and also the built environment for those countries that have decided to include the built environment into their national law. So there will be 6 harmonized standards, and therefore, depending on what requirements you are affected or you need to comply with, you will need to follow the procedure and refer to these standards or other technical specifications that may be prepared by the Commission. For example, on ebooks. Ebooks are not covered as such by the EN 301549, but it is expected that the European Commission will draft technical specifications that will refer to the current industry standard as for ebooks. So it really depends, but the most important thing, again, is to follow Annex 4 of the legislation.
Thank you. So David, one of the things Alejandro mentioned a few minutes ago was that you're not going to fix something overnight, right? So, we're a year and 10 days away from this happening, the deadline. I guess there's a 2-part question. What happens if you're non-conformant on June 29th? And then secondly, what are some of the things companies should be doing now to prepare themselves for this deadline, which is now 1 year and 10 days away?
I'll probably answer the second question first, because
That's fine.
I have more of an answer to it.
No, it's okay.
I mean, I think you're really having a plan that you can show to somebody that you are taking steps to address accessibility requirements is much better than not doing anything or panicking or diving too deeply into the weeds to address one thing in a very reactive way. I think that the plan needs to look at, firstly, inventorying your products and services to understand what you as an organization are responsible for that is subject to the requirements of the EAA. So firstly, knowing what you have then allows you to prioritize your efforts, and you will likely have a different strategy for something that already exists and is already available to the public. So a product or a service that you already have out there, which may be harder to fix. Then there are resources or products and services currently in development where you have a chance to course correct and improve the way that you address accessibility in the development or manufacture of those products and services. And then thirdly, resources that you haven't started creating yet, products and services that are still at the planning stage and you haven't started. Here, there's much less of an excuse not to include accessibility requirements right from the start. As we talked about, adopting the current version of EN 301549 and at least WCAG 2.1 level AA, ideally WCAG 2.2 level AA as an internal accessibility standard to work towards, will give you and everyone in your organization a common reference point. This is the standard that we want to meet in the products and services that we build. I think also from a pragmatic perspective, although a year or just over a year might in some cases seem like a long way off, in other cases it seems like it's going to be tomorrow before we know it. There will be a need to prioritize efforts, especially when there are limited resources in the organization. So prioritizing what to test first, what to test against, and what to remediate. So by having a clear written plan that identifies how you prioritize your efforts, that shows you, that allows you to demonstrate to others that you're taking steps, even if you can't do everything immediately, you're taking clear steps to clear deliberate steps to fix things in a prioritized way. And at the same time as looking at existing resources, trying to build capacity in an organization. So that means integrating accessibility throughout the product or service development process, from establishing requirements for the product through visual and user interface design, development, testing, involving people with disabilities in the design and development process. This is a really crucial part to demonstrating that those functional requirements are met, to provide evidence that as far as possible people can do things. I think somebody's on
yeah, so if we could, just as a quick reminder that if you've joined this webinar, definitely mute yourself and turn off your video. Thank you. Go ahead, David.
Yeah, and you're building capacity in teams as far as possible. Accessibility, as we always say, is a team game. So making sure that across an organization, people have the requisite knowledge and skills to meet their accessibility responsibilities for the job that they do. So providing training and resources to support that knowledge acquisition process is really important. Documentation, we've talked a lot about documentation already, and documentation is mentioned throughout the European Accessibility Act in terms of you have an obligation to document the accessibility features of the product or service and provide that documentation in an accessible way. Somebody in the chat asked a question about does the EA require the publication of an accessibility statement? And while I don't think, and Alejandro, correct me if I'm wrong, I don't think there's the same level of specificity as the public sector directive in terms of an accessibility statement in a specific form. I think it's a good idea for service providers to provide an accessibility statement on a website or referring to a mobile app or other technology that explains how the product has been built with accessibility in mind, and especially if there are any known limitations and ways where people can get assistance in terms of workarounds.
Indeed, one could even argue that the Accessibility Act is more ambitious than the accessibility statement of public sector that was specific, that needs to follow a specific format. Because if you look at the Accessibility Act requirements for services, one of the key general, let's say, requirement for all the services is to provide information about the accessibility of the product itself and how this interacts with assistive technologies, for example. So having that information in accessible manner about the accessibility of the service itself is obviously crucial for customers with disabilities, yes. And companies can decide to do this in the, I mean, you will not have a prescriptive way to provide this information, but they will need to provide it because it's an obligation. So that is even, I would say, like more ambitious sometimes than for the public sector that had a specific format to follow.
So Alejandro, you have a disability,
Yeah.
and you probably use some assistive technology to be able to do your
Yes.
job and things like that. Do you see a place where companies could be working with disabled folks to be able to, people with disabilities to be able to actually test and verify and make sure that their products and services are being accessible?
Yes, totally. I mean, the one of the key recommendations that we make to companies, following the guiding motto of the international disability movement, which is nothing about us without us, is to reach out to the non-users, because sometimes companies are focused on the average user or the user they aim for, but without reaching out to those who don't use their services. And by doing so, you can understand firsthand what are the barriers and what are the difficulties that people encounter when trying to access, or why they simply don't access your service because of accessibility. Another important recommendation for companies is to increase the diversity in their workforce, so to hire people with disabilities. And by doing that, for sure, that will have a positive impact in the organization itself, and the outcomes will be beyond just having a more diverse workforce, but will also improve, the approach of the company to making their services or their products more inclusive to everyone. The standard that I'm sorry to go back to standards, but the standard that I mentioned before, which is one of the standards that are being revised at the moment, the standard on design for all, which is the kind of the European way of saying universal design, includes is very much based, for those who know, the ISO 9000. So it includes recommendations and requirements for any organization, whether you are a company or a public administration or even an NGO, to have the internal processes in such a way that you have a universal design approach that will contribute to more accessibility outcomes. So one of the requirements is precisely to reach out to those non-users and to change the internal procedures in the company or the organization to ensure these kind of accessible outcomes. So it's being a little bit neglected, this standard, because we are all crazy for the EN 301-549, but this other standard for the service providers, I think it will be crucial. And I think loads of companies will benefit from having this universal design approach internally.
So David, you've worked in the kind of UX disability sector for quite some time, the user experience, and you've done, work with companies where you bring people with disabilities to test, verify, and stuff. And do you see a huge value in that process for companies to kind of engage with that community, with this community?
Absolutely, for all sorts of reasons. I mean, again, when we look at the requirements of the Act, we're looking at ultimately ensuring that the functionality offered by a product or through a service is available to and usable by people regardless of a disability. And while testing against standards can get you a significant way towards understanding if you've achieved those goals, the best way is to involve people with disabilities in verifying that you've met those requirements by demonstrating or that those tasks can be completed by people without vision or with limited mobility or some of the other performance criteria that are specified, but also involving people with disabilities early in design and development allows you to be informed and get you headed down the right road, rather than choosing a solution and then figuring out, how do we make this accessible, and how do we, let's do some testing and then do remediation afterwards. By including people with diverse disabilities early in understanding what it is you're trying to build, that allows you to make informed decisions, and that sort of co-creation focus of universal design or inclusive design again speaks to Alejandro's the mantra he shared of nothing about us without us. Without us that starts with co-designing a product rather than waiting till something's been built and then doing usability evaluation. So I can see a huge increase in that sort of inclusive user experience focus, in addition to greater observance of standards.
And this next question is kind of for both of you.
Matt?
Yeah, go ahead, Alejandro.
No. I was going to mention that I see questions coming in the Q&A in case.
Oh yeah. So, David, is there any other questions we want to jump into, knowing that we probably have a little over 2 minutes?
There's a couple of things that I'd like to address. One is people have talked about exceptions, and while we obviously want everything to be made accessible, there's a commercial reality reflected in the text of the legislation that set out some exceptions where the requirements either will not apply at all or will not apply for a given time period. And I wanted just to briefly mention some of these. So somebody had asked a question about whether how the EAA is similar to the Americans with Disabilities Act in terms of proportion of kiosks to meet requirements. And in the case of the European Accessibility Act, it's more a time limit after which which provides some level of exception. So any kiosk that's already out in the market can remain on the market without needing remediated for accessibility requirements, but any new product or new kiosk introduced would have to meet the requirements. So there is I think it's up to 20 years that an existing kiosk could remain available in public, but any new kiosk introduced would have to meet the requirements, which is different to a percentage of available machines. And that kind of speaks to the challenge of the financial challenge of replacing everything perhaps before it's reached its end of life.
So David, it's interesting, the term you just used, I want to make sure I'm clear on it. Product introduced, does you mean any new product deployed after June 28th, 2025, not that the product is the same make and model that was there. It could keep going, being deployed after that date. The model would have to be updated to be accessible after that date. Any new deployments of those kiosks. I don't know if I made that clear.
Yeah, and it's a good question, and I'm going to look to Alejandro for clarification of whether.
Sorry, I didn't
No,
follow you.
I have a self-service terminal. I'm going to use it more broad than just kiosk, right? But I have a self-service terminal.
Yeah.
And today it's not accessible, and it's model number A. And come June 29th of 2025, somebody else orders that same model number and it's still not accessible. Would they be able to deploy that?
No.
Even though, say again?
No.
No. Okay.
So the ones that are being used at the moment in the EU market, those can use this this extension in time. But the new ones will need to comply with the accessibility requirements.
So even if it's the same model number, it would have to be updated to meet those requirements after that
So
date.
it will not be the same model.
Right,
anymore.
right, exactly. In other words, model number A1. But
Exactly.
yeah, so you have to fix it.
Yes.
And it's interesting. So the one of the requirements is the CE symbol, right? Which is being used today in Europe, correct?
Yes.
Yeah. So is there any indication that that symbol actually changes on the 29th of
No.
okay, of June of
No,
next
I
year?
mean the CE marking is the CE marking. We are not an expert organization
No, that's fine.
in consumer policy, so this kind of. But I mean, for the consumer, from the perspective of persons with disabilities, the CE marking will not say anything. I mean, you
It
see,
doesn't really, yeah, I mean, that's why
it doesn't really help people with disabilities.
Yeah,
It's something for the market surveillance authorities and for the product manufacturers to bear in mind, and for the purpose of enforcement of EU harmonized legislation. But from the consumer's point of view,
they can't look at it and say.
it's just two letters
Okay.
that do not say much to many people. But they are important as for enforcement, of course.
So we have a few minutes left, and I want to make sure I get these in. So who's going to go around and look and make sure that these products and services are going to be up to reporting by individuals that something doesn't meet? And either one of you can jump in on that.
Can be anyone. So the market surveillance authorities, which because of this system, each member states have appointed different national bodies to enforce the legislation. And hopefully we will at some point have a list of those enforcement bodies. Those authorities will be the ones which will check the compliance of the products. Consumers, so people with disabilities, and more importantly, also organizations representing people with disabilities, will be able to call for enforcement, to take redress. And the legislation allows, which I think is very important, not only for penalties, which obviously are different in each member state, but also, which is even, I would say, more important, for the withdrawal of a product from the market, meaning that it's not to take out all the products. This was proposed in the original directive, but in the final text was not included, is the possibility for a market surveillance authority to enter into a negotiation with the company. Okay, you are selling these TVs and the TVs are not accessible. Please fix it. If the company, the TV manufacturer, is not correcting and is not aligning with the legislation, the market surveillance authority can make that company, can make this product stop from being sold in not only in this EU member state, but in the whole EU market. So I think that gives, I mean, that will be obviously the last resort. And first they will go into mediation and so forth. So the company will hopefully correct the issues before getting into that last scenario. But that is foreseen in the legislation, not only penalties, but also to stop that product from being sold in the EU internal market.
And the penalties are being set by each individual member state, correct?
Yeah.
Yeah.
Yes.
Okay. So you could, in one country, you could go to prison. The next one, you could be fined. I'm joking. But I don't know. I don't know if they really go to prison, but jail time.
Hopefully not. But
hopefully
maybe
not.
yes.
Yeah. Well, maybe that'll encourage it to be done. So I want to go, and maybe you guys can go back and forth on this. So I want to, with a few minutes left, I'd like to, and by the way, I don't know if there's any additional questions, David. So just make sure that we get those in if we need to, and if not, I think that we can work together as a follow-up to this for those who have attended any kind of blog or content that may be able to be shared. One, I'm gonna name off some services or products and you guys tell me if this would be covered. I'm sure there's variations, but let's start with like a payment device at a restaurant where they bring a payment device to the table and you need to pay your bill.
Yes.
That'd be covered. Okay.
Yes.
David, I'm buying new shoes on a website and I need to go through the process of picking my shoe, my size, paying at the end, putting in my shipping info, whatever. Would that be covered?
Yeah, that would be covered.
Okay. Alejandro, need to buy a train ticket from Rotterdam to Amsterdam. And I'm gonna do this at a device at the train station. Would that be covered? Like
Yes. Yes, I
a
presume so. Yes. Yes.
payment like a payment terminal where I'm going up
Yes.
to it.
Yes. Yes.
And I gotta pick my starting location, my ending location, time of train, put in my money, whatever. Okay. David, a library has self-checkout for picking up a book.
Yeah, that's anything. I mean, it talks about check-in terminals, but checking something out as well, I would imagine would be covered. Now, just before you come up with another, there are several additional questions, probably too many to answer.
Let's do it.
I do think that we probably are going to have to do a
Answer
follow-up
some by
blog
written.
post.
Yeah.
I
think a blog.
And a lot of them are around.
Sounds,
Is this covered? I think one interesting one that was asked was, does the EAA apply to US-based companies that have customers accessing their web-based services in the EU?
a great
Alejandro,
question.
I'll put that over to you. I mean, I guess it's part of the where is the market? Where.
I guess again, no lawyer here, but our understanding is that if the US company is operating in Europe, then they would be covered.
If a EU citizen can access that service, even if it's hosted by a US company, then the EAA does apply because it's available.
So you mean an EU citizen accessing an online service in the US? So, for example, if I
let's use the shoe store that, let's say I'm buying shoes online and the only shoes I'm ordering them from the United States, but I'm buying it on a website that I'm sitting over in Europe.
But the company is in Europe or in the US?
US.
In the US. Then I imagine that company is under the US law, not the European one.
Mm-hmm.
But again, that I'm doubting on this one.
It gets complicated. This one gets complicated.
Yeah.
David, other questions?
So I will not get through them all, but one question: to which extent are accessibility consultants liable when things don't work as expected? Can they personally or the company they work for be liable? And again, without being a lawyer, I don't think the EAA would place liability on an accessibility consultant. And I know there has been draft legislation in California which starts to
website
talk
developers
more about responsibilities of developers, but I think that any liability that an accessibility consultant might be under would purely be a contract between them and the client that they advise.
Sure.
I don't think there'd be anything in the EAA that kind of places liability on an accessibility consultant.
Mm-hmm. I agree. Yeah.
Either.
Matt, I came in here as well because I think.
Oh yes, Catherine.
That's okay.
Yes.
I think some of the questions are not possible to cover. It's been really interesting to see the level of detail that the audience are interested to discuss in. So I think I added in the chat box the toolkit on the transposition of the European Accessibility Act that we developed in EDF primarily for our members to support transposition at national level. But I don't think that will cover all of the issues. I do think that companies offering services to the EU market, meaning customers in Europe, are covered. But I think that we do need to clarify this. And it was clearly a question that was asked by a number of participants today. So
Yeah,
I think responding via blog post on some of them would be like really useful and interesting.
Yeah.
Yeah, so I definitely think that to wrap this up at some point is that we'll take the questions, develop some content that we could share with the participants here and blog, do a joint blog maybe on this, because I think there's some clearly, things are going to change and we're going to learn more over time as well. But the main kinds of themes still exist, and one is one of the themes I heard out of this today was functional accessibility. And if you're able to perform the tasks that are intended by the product or service, then it's a good thing, right? So that's a good starting place, right? Like if my goal is to buy an airline ticket and I go up to a kiosk and I can do that, or on a website, then I can do that, then it probably, you're in good shape. If I can't perform, I can't buy, I can't submit, whatever that is, then I have a problem. And so those are some of the things that I think companies should be starting with when you start looking in at what you're building and developing and providing as a service. Any final thoughts, Catherine, Alejandro, David?
No, I would just say that do not focus on what is covered, what is not. Just start to invest in accessibility, as David was mentioning before, because this is never white or black. So work with people with disabilities, increase diversity in the workforce, and invest in accessibility in whatever you do, even if you are not covered by the Accessibility Act. It's always positive, and you will see it also economically. So they start today.
Yep, and I would just add, work towards the familiar standards that exist for digital accessibility around the world, even if your own product or service may or may not be covered by the EAA. There will be other users where there are legal obligations. So focus on those common standards. This is about harmonizing efforts rather than splintering or providing different requirements from one territory to another. So focusing on a common standard, WCAG EN 301549 will get you a very long way to meeting your obligations and providing inclusive services and products.
Great, thank you, David, and thank you, Alejandro. I'm not sure if Catherine's still on. She had another meeting coming up. I want
to say thank you to you all as well, and to our audience. I know somebody just mentioned there, does it finish in half an hour? It's finishing now, but I think that we know that there's an appetite to have more information. So definitely we'll do the necessary answering of all those questions and come back on it.
Excellent. And I think we'll share both the European Disability Forum and the TPGI blog areas. So we'll get those out to everybody as well, because that's where we'll share content and continue to watch where this goes. I really appreciate everybody's time today. This has been great and wonderful working with the European Disability Forum. Thank you from TPGI and Vispero. And we look forward to continuing the conversation on the European Accessibility Act. Thank you very much, everybody.
Thanks, everyone. And
Bye-bye.
thank you to our interpreter and captioner, and to the team organizing the event today. Bye, everybody.
Thank you.
Bye.
Bye.